Hello, you guys. Good morning. Happy Wednesday. I don't anticipate us having a big meeting today just because it's right before the holiday and most people are on the road on their way to their destination for their gathering of 10 or less. Just saying. Please get off the road about 5 o'clock today so I can drive home in no traffic. I would appreciate it.
Good morning, Patty.
Good morning. Good morning.
Are you back in town?
I am.
Okay, I've missed some meetings, so that's why I was asking.
I'm back currently at Fast Evict. I'm out helping them with everything that's going on. So I am in town. I'm at Fast Eviction Service and I'll be back here on Monday, but I'm leaving today at 5. It's my birthday.
Sounds good.
I'm like, I'm gone. Let me get out of here. Does anybody have anything they want to talk about? I do.
Yeah. I haven't been able to attend some of your meetings due to other issues going on at the office, but in reference to the tenants not paying their rent, are they obligated still to, can they provide us some type of verification that they're not receiving any type of income and this COVID is affecting them? Because an attorney told one of my clients that she needed to send them a letter with, giving them 15 days to supply her with any type of evidence that they're not receiving any income due to COVID-19.
Okay, it's not just income related, just so you know. Okay. I think it's 5 different reasons. They could be affected by COVID. It could be increase in expenses because of COVID.
Mm-hmm.
Have you had an increase in expenses because of COVID?
Every time I walk into that grocery store.
Every time you wear a mask. Mm-hmm. Every time you use hand sanitizer. The reality is each and every one of us has been affected. Affected is a very big word. Covers a lot of things, right? So it doesn't have to be financially affected based on the moratorium and the way that the statute's written.
Okay.
Yes, it is a 15-day notice for any charges that are monetary, meaning money, late fees, because we can start charging late fees as of September now.
Okay.
So late fees, utility bills, all would go on a 15-day covenant notice. And then the rents would go on a 15-day notice to pay rent or quit. So here becomes my question to you. Please pay attention. When's the last time you were in the unit? What kind of modifications to the property did they make without written consent of the landlord? Did they install a Ring doorbell? Did they paint? Did they change the locks? Are you getting what I'm trying to put down? Stop chasing the money. Technically, if they say that they were affected by COVID, and let's face it, who hasn't been affected by COVID? Everybody's been affected. Affected is a big word, okay? They owe 25% of the rent for all the months that we were on lockdown, all the way to March, by January 31st of next year. The rent's not due yet. Why are we chasing it?
Okay.
You with me? If you serve a 24-hour notice to enter to do necessary or agreed upon repairs or a preventative maintenance inspection, and they don't allow entry, they're in violation of the law and their written agreement. That would be a 3-day curable breach of covenant. And if they still don't let you in after that 3-day covenant expires, I would serve them with a 3-day notice to quit and start the eviction based on a material breach of the lease.
Okay.
For the last 20 years, every time we called our attorneys, they would always tell us the same thing. We'd tell them this long story of all the nonsense the tenant was doing. And they always asked us one question, but did they pay the rent? And as soon as we said, no, that's the worst part. They're not even paying me either. The attorney always said, okay, Forget the drama. Let's go after the money. That's the easiest way to get them out in the state of California. On September 1st, the planetary alignment has shifted, and now the money is the hard way. The drama and building your case based on material breaches of the lease and presenting that properly to the judge, that long, hard way, is now the easy way. Okay?
Okay.
You with me?
Yes.
Go in there, see what they're doing. What's the first thing all of us do when we buy a new house? We change the locks because we don't know who has a key. If they did that too, and there's something in their contract that says that they can't make modifications to the property without written consent of the landlord, I think you just got them in a loophole. You get where I'm going? Yes. If they have unauthorized pets, unauthorized occupants, it's filthy pigsty in there. They're not maintaining the landscaping. Whatever the rules of your written contract are, is what you need to be in there looking at. And don't get in a confrontation with them. Don't use your mouth to get yourself in trouble. Just go there, do your inspection, and then use your notices to talk for you.
How about underage occupants?
What do you mean underage?
Someone living there that's underage, they added an extra tenant.
You need to be careful with that because people have babies all the time and we can't discriminate for that. So if they have more children living with them, you need an occupancy standard in your rental agreement and on your criteria. In other words, this unit is for 3 persons only, or 1 person only. Don't use the word single because then it sounds like you're discriminating against a married couple versus someone that's single. When you're talking about single, just use 1 person, 2 persons. That way it doesn't matter how old they are. Does that make sense to you? The occupancy limit on this property is 3 persons. That's it. No other persons are allowed.
For me, it's 4, and like a 15-year-old boy has been living there for a few months. So,
okay, serve them a 3-day curable breach of covenant that they have unauthorized occupants and see what kind of a response you get.
Am I able to charge more for that?
What city are you in?
Whittier.
No. Unless you made that a term of your lease, no. But hear me out. Let me rephrase that, okay? This is what I would do if it were me. I would serve them a 3-day curable breach of covenant for the unauthorized occupant in the property. The first thing the tenant's going to do is pick up the phone and call me. They're going to start talking to me. It's called the interactive process. This is when you can explain to them, well, that house wasn't structured for that. I'm not okay with that. I want to limit it to 4 persons. You need to get rid of the additional occupant. Or you could say, I can make an adjustment for you. We can do that. We're going to increase the rent by this amount. New rental agreement contract at that point. You're changing the terms because they're changing the terms. They brought more people in. See how that worked? So you can come to an agreement, sign a new month-to-month rental agreement, adding the other person at the higher rent amount. But everybody has to sign and agree.
So formally, you have to close out the other one like they moved out and rewrite a new one as they started living, for example.
You can sign a new lease contract or a new month-to-month agreement at any time during the tenancy as long as all parties agree.
Ooh, with new adjusted rent.
You're with me now. You're understanding what I'm throwing down. They changed the terms. So now technically you're entering into a new agreement with the new added tenants, with the new increased rents, yada, yada, yada.
I see. Oh.
Okay, I see that smile. So you're like, I get it, I get it. If they don't agree, you can't force them to sign it. You can't force them to pay the higher amount, but they're still in violation of their lease contract with unauthorized occupants, which could be a reason for you to start an eviction. Okay.
The
So your old lease still keeps you in control until a new lease is signed, and then that new lease controls. So you want to make sure when you do a new rental agreement that you don't mess anything up, you guys. A lot of people leave the late fee blank because it's already that way in their original contract. When you sign a new one, the original one is now trash. So now you don't have a late fee. You got to be really careful what you're doing to make sure that those late fees are carrying over. Okay. Just because it's in one contract, when the new contract comes into play and everybody signs it, that's the contract that controls. So if you forgot to put it on the new contract, then you forgot it. So be careful what you're having them sign. Double check it, triple check it, make sure everything's on there.
Does the new lease, the new rental agreement, the new one, does that bring up the 12 months? You know, the new law, the new rental state law. AB
No, they're still in there. So you're still going to have to pay that last month relocation fee. It doesn't have anything to do with the agreement. It has to do with the time that they've been in the property.
So that doesn't bring up the whole new 12 months that we have, that whole 12 months trial period with.
No, but thanks for trying to think outside of the box. And here's my thing. If you guys don't want to pay that last month as a relocation fee, stop putting people in your property on a term. Put them on a month-to-month. If you hate them by month number 11, you can give them a 30-day notice and they got to go. No reloads.
Well, I am in that situation, but month 10, COVID happened. So
I get it. I understand. You're kind of in a bad position because of COVID. Aren't we all? I mean, come on. I get it. Under normal circumstances, we would be month 11, 30-day, bye-bye. But unfortunately, COVID has impacted our entire planet.
Patty, for example, with that 12-month lease, most of my tenants are 12-month lease. It's a 12-month lease, and then it converts to a month-to-month. 90% of my units are under, rent control. So I don't have to worry about that relocation because it converts into a month-to-month?
No, you automatically owe the rent. If they have lived there, if you're in a rent control property within the state, not in the city of LA. I'm not talking about city of Los Angeles, okay? I'm talking about AB 1482 covers the whole state. As soon as someone has lived in a unit 12 months or longer and you want to terminate tenancy, you have to pay their last month's rent. What we're talking about is don't sign them up at hello for a 12-month contract. Put them on a month-to-month. Put them on a 3-month lease. So you're guaranteed 3 months. And then you can change the rules after that. And if you don't like them by month number 11, you can give them a 30-day notice to vacate and you don't owe those relocation fees. That's what we're talking about. Okay. Does that make sense?
Yeah. So, but what I'm getting to is the contracts that I had under the 1-year lease that are now month to month, I don't have to worry about that relocation anymore, correct?
No, you owe them relocation fees because they've been there longer than 1 year.
Oh, okay.
So what that clicks in at is when a tenant moves into a property, if they've lived there for 1 year or longer and you want to terminate tenancy, 30-day notice, 60-day notice, whatever you're doing, you have to pay them the last month's rent as a relocation fee.
Yeah, okay.
If you want to avoid that, don't put them in that 1-year contract to start. You're immediately signing up to pay them relocation fees. You could put them in an 11-month contract, and if you like them, you could just keep them there on a month-to-month, knowing that you're going to have to pay that when they vacate. Yeah. If you don't like them, or it's not working out, or it's more challenging, you could serve them notice to vacate prior to that year and not owe the relocations. Okay. A lot of corporate America is getting rid of the 12-month lease contract because of this. They're going to either 3 months and then a month-to-month, or 6 months and a month-to-month, or 9 months and a month-to-month. They're figuring it out how they want to do it. Okay. All I'm saying is if you sign somebody up with a 12-month contract, you're automatically signing up to pay them to get out.
Does that also fall for example, commercial? Do you know?
It doesn't, AB 1482 does not
Just
affect
residential. Just
residential dwellings. Absolutely.
Okay.
And if the tenant brings in a roommate within the first 12 months, the clock starts over with 12 months. Okay. So within the first 12 months, if they bring in a roommate, then that clock starts over. So it could turn into 24 months very quickly instead of 12, depending on what your tenant does.
Yeah. Okay. All right.
All on a case-by-case basis, I know.
Mm-hmm.
Okay, is everybody paying attention? Oh, somebody wrote me a question. Let me see what it says. Hang on. Do you know when we are allowed to give rent increases in LA County? I heard until December 31st this year, so I could give a 30-day notice increase for the 1st of January of 20, I think you want to say 2021, not 2020. Most likely, but let me say this, and please heed my warning. Another COVID lockdown is imminent. Let that sink in for a minute. What I'm saying is China's been locked down 3 times. Italy's on their 2nd lockdown. What makes us think they're not going to lock us down again? Our numbers are blowing up. They're off the charts in multiple states, not in 1 or 2, in multiple states across the board. I have a feeling they are going to lock us down again. I have lobbyist friends in Sacramento that are warning me, you're probably going to go back on lockdown. So if you want to go fishing, you better go now. If we get locked down again, which in my opinion is inevitable, looking at the rest of the planet as an example. Okay, because I don't know, my crystal ball is broken. It's going to become harder and harder on landlords. They will continue to make protections for tenants. They will continue to help assist them with rent payments and prolonging the rent due dates and things of that nature. And everybody's concerned about this big wall of evictions that's going to be coming, you know, as soon as we're allowed to, you know, watch out for February because there's going to be this big wall of evictions. It's going to be a big wall of foreclosures. How long do they expect us to be able to hang on without getting any income from the tenant? I mean, we really need to start thinking not outside of the box here, but outside of the building. The justice system is turned into just us. Okay, it's just us. We got to figure it out because we're not getting a whole lot of help from the court system. And things we were able to do pre-COVID, we're not able to do now. I mean, come on, they don't have to pay us, but 25% of all the rent that's due by the end of January of next year. So for everybody that's chasing the rent right now, know this, document the rent, but stop chasing it. It's not due yet. Everybody got that? The rent is not due yet.
So for other cities, rental increases in LA County that are...
As long as we have an order to shelter in place, don't increase any rent. It's too risky. And let me give you the why, okay? And I get it. I hear you, okay? We all want to raise our rents, but hear me out. We still haven't heard from the Department of Fair Housing over what's a reasonable amount of time to wait after a global pandemic to increase rents or terminate tenancy and it not be considered retaliation. Why haven't we heard from them yet? Because we're not off a lockdown yet. And if we get locked down again, it's going to get worse, not better. Now, if you've increased rents, you're going to have to backpedal and issue a rent increase or a decrease to your tenant. And how does that make us look as landlords? I know I illegally raised your rent, but I gave you a credit. I mean, it just sounds horrible. Sounds like you don't know what you're doing. We don't want to implement that. We don't want to put that thought in their head. Would you not agree with that? I mean, once you get wind that somebody doesn't know what they're doing, that's a great way to take advantage of them, right? We don't want to boldly admit we shouldn't have and we did, but we're going to have to. You get where I'm coming from? Is it worth that $65 more a month? No, it's not.
No, I was just asking to when is.
I know. And I'm trying to make sure everybody understands. Just don't raise the rent right now. The risk is too high. In the event that everything falls into place and we get put back on freedom as of January 2021, yay! And they release everything and COVID goes away, then yeehaw, raise your rents, do your thing, yada, yada, yada. But for right now, it's just too risky. I'm not raising any rents. I'm not touching anything. I'm not doing anything with the finances that way. I'm trying to also use it as a reward to my tenants that are paying. I know COVID's hard and you've still been paying me, so I'm not going to increase your rent this year. The reality is you can't. but now who sounds like the nice guy that knows what they're doing? You get what I'm coming from? It's all part of keeping that balance right too. Once we get that balance out of whack, that's when everything goes haywire and we need legal assistance. So just something else to think about, okay? I wouldn't go increasing rents anytime soon.
How would you, and I've missed a few meetings, I have to work.
It's okay, it's okay. That's why I'm here.
Handle late payments. My tenants are now paying whenever and are returning my call. They are paying. I'm happy for that, but whenever. Is there a notice? I can't do the 3-day pay or quit during this.
You can do the 15-day pay rent or quit, and it's a 15-day covenant notice for all monetary issues. So let me explain. Late fees, utilities, anything they owe you money for other than the rent goes on a 15-day curable breach of covenant notice. For all lease violations, unauthorized pets, unauthorized occupants, modifications to the property without written consent of the landlord, those things are still a 3-day curable breach of covenant. This is really weird. My Zoom meeting is trying to call my phone right now. Weirdest thing I've ever had happen. I'm not touching it.
How would you handle basic little things like noise levels, out of control noise? I guess with me here, people are not working and the noise levels are through the roof. I never had that before. So what kind of notices are that? That's not a 15-day, is it?
3-day.
That's a 3-day? Stop your noise?
I would send out a letter to the entire community, and this is just me talking. With more and more people being confined to their homes with the government order, we're having a little bit more noise than we normally would under pre-COVID circumstances. Therefore, I'm reminding all of you to monitor the noise level in your apartments so that we treat everyone the same and everybody has a right to quiet enjoyment. That would be the letter I sent out, okay? Very broadly written, basically telling them keep the noise level down. Please know that you have the police to help assist you with noise complaints, so you don't have to deal with them all yourself. If you have the police going back to the same units over and over and over again, that's when you can do a 3-day curable breach of covenant for right to quiet enjoyment and a noise nuisance, yada, yada. You have the police incident numbers to back it up. So it's, again, it's the hard way. You're having to build the case, but it's what we do. You know, as property managers, we've been building cases for a long time going, if this one ever goes to court, I'm going to have all my ducks in a row, you know, and we do that in the file. We're just building a case based on that, on all those ducks, you know, they add up over time. Did that help?
Yes.
I mean, I'd love to be able to sit here and tell you guys, okay, this is going to happen. This is happening. This is what's going to happen next. And that's what's going to happen. But the reality is my crystal ball's broken. And all I can do is make assumptions based on other countries, because we're all still on the same planet and they're all getting locked down. Why wouldn't we? And people say, oh, we're not locked down anymore. You're locked down until the library's open. You get where I'm coming from? We are officially locked down until the library opens. Library's not open yet.
So we have to suck it up for now. Suck up a lot of things. Yeah.
Well, like I tried to say in the very beginning of this, we're no longer driving. COVID-19 is. We're along for the ride.
Yeah.
Not a whole lot we can do. We don't have any control. We can only react.
Yeah.
But if you're trying to get somebody out, stop chasing the money. Quite frankly, it isn't due yet. How do you kick somebody out for not paying you when it's not due yet? Okay, just saying. It's too risky. So a better choice might be to go there and see if they're in violations of their rental agreement. Go inspect. When's the last time you were in there? God knows what they've done during COVID. They could have remodeled the entire interior because the only two stores open supposedly were Lowe's and Home Depot. So maybe you have a jacuzzi in the living room now. You never know.
Because I do have one of those clauses. They need permission, and I guess I should be fine with it. Is a big screen hung on the wall, which a lot of people are doing now, which I didn't like because
when they move out, it leaves giant holes in your wall.
These big old, they crack the studs, these huge.
They split the studs with the bolts they put in. It's a modification. It's a modification to the property. When you attach, I can tell you this being a licensed real estate broker, okay? Once something gets attached to the real property, it becomes real property and is no longer personal property. I'll give you an example. You put in a new ceiling fan, okay? That's now real property because it's attached to the real property. You got me? So by them mounting a big screen into the foundation, which is what they're doing by putting it into those studs, it becomes real property and is no longer personal property. But they always seem to take it when they move out and leave those big holes in the wall.
They're going to try to just put a little
duct tape.
A little patch and say, there you go, fine. I
had somebody one day scotch tape lined paper and then put toothpaste over the top of it like I wouldn't notice. My good night. Come on, I didn't fall off the turnip truck yesterday.
what would be, in your opinion, course of action or something like that? I saw it, and I guess they're
3-day curable breach of covenant. A Ring doorbell system, same thing. Video camera system, same thing. Painting, same thing. Changing the locks, same thing. Installing ceiling fans, same thing.
But right now, it has no teeth. During COVID, it has no teeth, right? The 3 days.
Yes, it does. Yes, it does. You're not asking for the money. So all those protections about money don't come into play. This isn't about money. They're in violation of the rules. You're welcome. Unauthorized pets, unauthorized occupants, failure to maintain the landscaping, all material breaches of the rental contract that have nothing to do with money. Therefore, none of the COVID protections kick in. See how that works?
If they fail, I can take action. If they fail to bring this thing down, and I can take court action. Now I just got to think about this. Court action that's.
Listen to me. Just listen to me. You have a tenant that's living in a property and they're paying the rent every month, okay? But they're damaging your property. Can you still evict them?
Under COVID? I think.
Under COVID or not under COVID? Can you still evict them?
Yes.
What are you questioning?
I'm questioning under COVID, can I move on this legal action? We're still
under COVID or not under COVID. You're not asking for the money. Remember, the money's not due yet.
Would it be a problem, me not saying nothing for now? Would that be like endorsing it or accepting it?
It's called a waiver, sir. Once you have knowledge of something and you accept the rent, you could be waiving your right to do something about it. Does that make sense to you? Especially in LA City, you have 30 days to react. If you don't react in 30 days, you waived it. That's how that works in LA.
LA City.
What area? Where's your property?
Whittier.
You're still in LA County, so it could be questionable. I'd have to go ask one of the attorneys. But, and this is my question, are we going to have a card we're going to get to pull out later and say, well, we didn't want to put them out during COVID, so now we sound like the better landlord? I don't know. I'm not telling you that we have that card to pull, but hey, every once in a while, we need a card somewhere, right? Yeah. We didn't want to put them out during COVID. We had an order to shelter in place. However, now that we're out of COVID, I'd like to move forward.
That's how I like to play it, but yeah.
Hey, it's something to definitely ask your legal counsel. Is this a possibility? Is this, because remember, I don't do that part. I don't enter the courtroom unless I'm battling my own battles. So I can't give you guys legal advice at all. At all. My experience is property management based.
When COVID is behind us, and I do a rental increase, I separate my garages separate, parking, and I do a rental increase on that. And I stick within the state's 5% and 2% when we're out of COVID. And I do an additional increase on the rental part, on the garages. And it all goes over the 7%. Go ahead, go ahead.
Let me stop you. Are your garage contracts on rental agreement forms, or are they on licenses? Let me give you an example. When you go to Disneyland for the day and you pay $30 to park your car there, you're not renting a space. You have a license to park there. It falls under license law and not landlord-tenant litigation. Make sense?
Yeah.
When you make it a part of your rental agreement in your garage, then it becomes landlord-tenant and licensing law doesn't apply to it. See how that worked?
Yeah. It's separate.
Okay.
Separate.
You want to make sure that you have a license for what you're doing as far as that goes, and it's not a rental agreement. So they are renting the garage under a license, and licensing law would then apply instead of landlord-tenant litigation.
Licensing law. Okay.
Yep. Talk to your legal counsel about it.
So that I think I meet that criteria. So tenant court doesn't apply to that, and eviction laws and all that. That's a whole different set of rules.
Right on the nose. Right on the nose. You're with me now. Okay. I gotcha.
My agreement.
Different laws, different rules.
It says parking agreement, but yeah.
Bingo.
Separate.
Bingo. You have a parking agreement.
Yeah, it's called parking agreement, but it is separate than the.
And if you read it, it may say somewhere, this is a license to park your vehicle. If it says it's a license, then licensing law applies. Just like parking your car at Disneyland and paying them $30, you have a license to park there, not an agreement.
I don't think it says that, but it does say separate.
Just look and see if it says this is a license agreement next time you're reviewing it. If you do, then licensing laws would apply and not landlord-tenant. Therefore, rent control wouldn't be a problem. You with me? Okay. Ah, there is light at the end of the tunnel.
Yeah.
Anybody have anything else they want to discuss? No? Nothing? Okay, everybody, hang in there. Have a great Turkey Day. I'm going to get out of here so you guys can go on with your day. If you need anything, let me know. You guys know how to hunt me down. I will be in the office again on Monday, and we will be doing a Widgets Wednesday with Widget. I'm going to see if we can get a guest speaker to come in and talk to us on Wednesday and give us an idea of what we're seeing in the courts now. I know that we're seeing a few lockouts come into place. We're getting lockouts now on evictions that were going on. People that are winning in court for non-payment of rent cases based on COVID rents. We are seeing no lockout prior to December 31st. So it's in compliance with the CDC's order. So you may win in court right now, but they're not going to lock them out until after the first of the year. When you go after the money, that's what you're dealing with. So just keep that in mind. And I know as we continue to get closer, we get closer to that date, but the chances of us going back on lockdown are high. They're high. Look at the numbers across the nation. We're hitting the highest numbers that we've hit. It's like I want to tell everybody, remember how we all behaved in June and July? We bought hand sanitizer. We used it all the time. We wore our masks. We were doing everything we were supposed to. Go back to that. Go do that, okay? It's just going to help us get through the process faster. You know, it is what it is. We're not driving. We're not in control. COVID is. But I mean, if we can go back to that mentality now, it may help us get back on track faster. I just want this to be gone already. I wish the wind would blow it somewhere else, but reality is it's not.
One other question. Probably
you got it.
You post these, I don't make all your meetings all the time, but you do post them on YouTube.
Yes.
Will you be posting this one on YouTube? I guess I should have stayed blacked out.
Everything's going to go back on the website for review. I've never watched it. Does it show you guys when we're reviewing? I've never
I don't think so. You know what? You're right. It doesn't show us, just you. Yeah.
Yeah, but you can hear, we should be able to hear you, but
Yeah.
not see you. Yeah, that's my way of making sure I don't expose you guys.
And that's what I use to catch up on the meetings when I miss them.
Okay, so it only shows me. I'm sorry.
Yeah. No, that's good. I don't want to be on
Okay.
YouTube. I don't want to be on YouTube. But my voice is fine, I guess. You haven't posted last week's on YouTube. I missed it.
I'll talk to my web guy. I don't do that. I have a web guy that does that for me. It's over my pay grade. So I'll make sure that he needs to know, hey, post that on there. Pretty much said the same thing last week is, where was I last week? Was I in the Sierras? I think I was in the Sierras last week. I'm always somewhere. Come on. I'm in Las Vegas. I'm in the Sierras. I'm always somewhere.
But I like them when people ask questions, because I have a lot of questions that won't come to mind right now. They'll just come later.
That's why I wanted to do this as a group, is because you get that question from somebody and that reminds you of something you wanted to ask. And I get it. Get a piece of paper, and every time you have a question, just write it down. I have no problem getting drilled with questions. I'd rather answer 100 questions than deal with one really bad problem. Because you didn't ask a question. I'd rather be that person that goes, no, don't do it that way. I've done it that way and it's not good.
Yeah.
So no, I would rather answer those questions and try to help everybody to the best of my abilities, by all means. That's why I do this. Help me help you. You know? If you have the opportunity, if we go back on lockdown and they offer some kind of programs for homeowners, jump on them. Once they're at their max capacity, then they're at their max capacity, and that's it. You're done. There's, you know what I mean? They're not going to be able to help everybody.
Right. Now, I heard through a friend who knows another friend that anybody who accepts this payment from the county, you have to also agree to not evict. It comes with the behind it. It comes with other agreements, not just accepting the money that the county is going to pay on behalf of the tenant. It comes
right. You also can't evict the tenant, right?
Next year.
Yes. You also need to know that if you got an extension from your mortgage company, because you couldn't pay because of whatever reason, if they gave you a 6-month extension and turned your 30-year mortgage into 30 years and 6 months mortgage because they gave you that extension, know this, your mortgage company is making interest off you for that additional amount of time. And that's why they're doing it. But you also can evict if you've received that. You have to then give that opportunity to the tenant as well. So what you're saying is spot on true. It's actually written out in simple English in AB 3088, that any benefits that the landlord receives due to COVID then has to be passed on to the tenant. So if you get assistance or a deferment in your mortgage for 6 months, you can't file an eviction until that deferment expires.
You can keep this from the court when moving forward with legal action and stuff like that. I'm sure they're going to bring it up.
Just so you understand, the Judicial Council changed the way that lawsuits are filed for UD actions on October 7th of this year. Courts opened on October 5th. On October 7th, the Judicial Council changed the way that evictions are filed and included a 4-page cover sheet asking quite a bit of questions about what kind of assistance the landlord may have received during COVID so that they can ask. So you're asked to fill that out, sign it. It's a new 4-page cover sheet that goes on the front of every eviction.
Oh.
So you're asking, how would they know, the bank? You're having to sign penalty of perjury that didn't happen. So just so you know, just so you know.
By the way, that hasn't happened to me. That did happen to me, but it was years ago.
I'm also trying to explain to you that there is already a system in place. Don't even try to play, okay?
Now, not to be confused with something that the banks did with me many years ago.
Okay, we're not talking about
years
ago. We're talking about COVID right now and nothing else.
Okay.
Okay. All right, you guys, if anybody has any questions, feel free to give me a ring. I'm going to go ahead and end this for the day. You guys have a wonderful Thanksgiving. And if anybody needs anything, let me know. All right, you guys have a good one.